All right, let's talk about a case that trips up so many people in Indian law, from first-year students to even some seasoned lawyers. It's all about audio evidence in matrimonial disputes, and it centers on one case that is constantly cited and almost always completely misunderstood.
You've probably seen this floating around. The case of Alika Khosla versus Thomas Matthew is often thrown out as the definitive authority, the final word, establishing that an audio recording and its transcript are admissible in court. Seems simple, right? A clear, solid precedent.
Well, here's where this story takes a pretty sharp turn. What if I told you that this common understanding, this legal mantra, is just plain wrong? What if the actual legal battle in Alika Khosla had nothing, and I mean nothing, to do with a tape recording?
So the obvious question is, if it wasn't about that, what on earth was it about? Okay, let's look at the actual case file. The case was presided over by Justice V.S. Agrawal, and it was a divorce petition under the Indian Divorce Act. The central issue wasn't a secret recording, it was a request for DNA testing of fetal tissue to figure out paternity because of adultery allegations. So the real legal question the court was wrestling with was this: how do you balance a person's fundamental right to privacy under Article 21 against the absolute need for proof in a legal case?